What's up, guys? Welcome to the Legal Doc Guy podcast, where we discuss bar exam questions and answers. And we also, just so you guys know, Legal Doc Guy is also a paralegal service company where we help self-represented litigants represent themselves by completing their court documents, California judicial forms, things like that. A lot of this stuff that we do is related to family law stuff, but we also do landlord-tenant issues and small claims, things like that. Pretty much any kind of legal issue you can think of. And we could also connect you with attorneys in our area, in the Los Angeles area. So I just want to put that out there. Also, please, if you like the video or if you get any value out of this video, please share, like, and subscribe, all that good stuff. So what we're doing right now is we are preparing for the July 2026 California bar exam. Today we're going to be going over an MBE question in criminal law having to do with the Fourth Amendment search and seizure. And we're just going to get right into it, guys. So here is the question. Here, I'll put this here like this, just so we can start it out. So as usual, I like to start by reading the call to question. Should the court grant the motion to suppress? Obviously, the woman moved to suppress evidence, seized. Great. I look at the question. No, yes. So I know it's a yes or no question. I know right away I'm in criminal law because it's talking about evidence seized. I could be in evidence. Could be an evidence question. They're asking, should the court grant the motion? So typically this would be more of a criminal law question. As opposed to criminal procedure, criminal law, they kind of blend together. Those two subjects are kind of blended together when it comes to criminal law and criminal procedure, which is not typical of a essay question necessarily, but in the multiple choice questions or MBEs, generally we just call it criminal law and procedure. It's basically just criminal law and procedure. Anyway, so here's the question. The police suspected a woman of dealing in stolen credit cards. Ooh. Okay, so she's got these stolen credit cards. They suspect her anyway. Right here, suspect her. An undercover police officer knocks on the woman's door and told her that he was willing to pay for usable credit cards. When the woman asked if he was a police officer, the officer replied no, giving her a false name and saying, "You can call Harvey. He'll vouch for me." The woman admitted him in to her house. Clearly, she knows who Harvey is and lets the undercover agent into her house. After she left the room to call Harvey, which is kind of weird why she went into another room to do that, but that's what she does. The officer lifted some papers off a desk and underneath discovered 3 credit cards bearing different names. He seized the cards, and when the woman returned, he arrested her. The woman has moved to suppress the evidence seized on the ground that her Fourth Amendment rights were violated. Should the court grant the motion to suppress? So let's go over and discuss what is happening here. So we got ourselves a woman, and she deals in stolen credit cards. How does the undercover agent know this? I don't know. We could assume that he probably talked to Harvey, this guy down here. And the police have it on good authority somehow, some way, that she deals in stolen credit cards. Because, you don't just go to someone's house randomly. They got some kind of lead. They got something. And obviously what I'm talking about right now is not really important. I'm just trying to make this conversation lively. But we know that the undercover agent or officer basically just goes to her house, knocks on the door and says, "Hey, man, I know Harvey. And, I know you got some credit cards and I want to buy some." It's kind of like when people sell their EBT cards, they get their EBT cards, and instead of using them on food and groceries, what they'll do is they will sell them. People do this all the time, and they get some cash, and they probably need the cash because probably want to use drugs. Who knows? Obviously, I'm just messing around, but this lady's selling stolen credit cards. That's what she's doing. The facts tell us that they have different names on the credit cards. So what's important here is that the officer gains entry to the house by giving her a false name and saying, you can call Harvey. So the question becomes, and we have to look at this chronologically, has the officer done anything wrong that would be grounds for suppressing the credit cards after he found them? But you want to take this chronologically. So the police suspect the woman. There's a reason why they suspect her for selling stolen credit cards. She deals in stolen credit cards. The undercover police officer knocks on the woman's door and told her he was willing to pay for usable credit cards. When the woman's like, has it in her head that if I ask you if you're a cop, you got to tell me the truth. There's like this weird belief out there amongst criminals that think that police officers have to tell them the truth whenever they're asked if they're police officers. And this is not true. Police officers do not have to tell you the truth. This has been litigated before to the highest court, and police officers are allowed to deceive you and lie and tell you they're not police officers when in fact they are police officers. And that's essentially choice A. No, because it was immediately apparent the cards were stolen. No, because the woman assumed the risk that the officer would seize the items and place at. No, okay, it's not A, B that I'm thinking of. Yes, because the woman's rights were violated when the officer lifted the papers. Or D, yes, because the woman's rights were violated when the officer obtained entry by deceit. Okay, so let's look at this one. Yes, because the woman's rights were violated when the officer obtained entry by deceit. So, as I said before, officers are allowed to lie. They're allowed to deceive you to gain entry. And the woman allows him into where does she let him go? The woman admitted him into her house. And after she left the room, so she leaves him in a room to call Harvey. So far, the cop hasn't done anything wrong. I could tell you that right now. She has consented and given him permission to enter the room. And she leaves him there. And so up until that point, the officer hasn't broken any rules. There is no illegal entry into the home. However, her consent or she's only allowed him into this room. She hasn't allowed him to go through her belongings or anything like that. She hasn't said, hey, wait here, help yourself, look around. She hasn't said anything like that. She just went into the other room to call Harvey. And so then the officer starts looking around, and it says here the officer lifted some papers off of a desk and underneath discovered 3 credit cards bearing different names. So clearly he lifts some papers up and he notices that, hey, these are stolen credit cards, right? And so the question becomes, when he lifted these papers right here, because this is chronologically, this is the next action he takes. Did he violate her rights here? So yes. So the answer here is C, yes, because the woman's rights were violated when the officer lifted the papers. Well, what you have to recognize in this question is that once he lifted those papers, that was a search. So was it a lawful search is the question. And just knowing what we know, we have 2 questions we got to ask ourselves. One, did he have probable cause to believe that there were stolen credit cards under those papers right here? He lifts papers off the desk. As soon as he did that, that is a search. The question becomes, was it lawful? Did he have probable cause to search? Well, there's nothing in the facts to suggest that he had probable cause. For example, if he had it on good authority that the credit cards were hidden under that stack of papers right there, I'm not even sure if that would amount to a probable cause. But there would have to be something in the fact pattern to suggest that he knew they were there. He didn't know they were there. He's just lifting papers. He's just after she left the room, the officer lifted some papers off the desk and he discovered 3 credit cards. There's nothing to suggest that he had probable cause to lift, that they were there. Okay. And 2, what is the other thing he would need in order to lawfully lift those stack of papers and find those credit cards and not get excluded? as a fruit of a improper search. Well, he would need a search warrant, which the facts, he doesn't have one. There's no facts to suggest he has a search warrant. So one, there's no probable cause, and two, there's no probable cause to believe that there's stolen credit cards underneath that stack of papers on the desk. And two, there's no search warrant saying that he could search there. So, bam, we know that this is a possible answer, correct answer, because her rights were violated. I believe her rights were violated once he picked that stack of papers up. But we need to just verify here. No, because it's immediately apparent that the cards were stolen. Well, that might be true. It might be true that it was immediately apparent that the cards were stolen. However, before he had a chance to even look at the cards, he had already violated her rights when he lifted the papers. So before he even looked at the credit cards or even saw them or noticed them, the fact that he did a search under the papers is where the violation occurred. It occurred right at the moment he lifted those papers off the desk. So, and it doesn't matter that they were immediately apparent that the cards were stolen at that point. B, no, because the woman assumed the risk that the officer would seize items in plain sight. So were they in plain sight? For something to be in plain sight, the officer would have to be, there's basically a two-prong step here. One, is the officer in a place where he's lawfully allowed to be? In this situation, the woman allows him into the room. All we know, into the house and into a room. All we know is that she let him in, into the house. See this word right here? Admitted him into her house after she left the room. So he's in the house and he's left in a room. She left him in a room. So she left him there. She gave him permission to be in that room. So he is in a place where he's lawfully allowed to be. So far, prong one, no problem. Prong two, he can only take an action he's lawfully allowed to take. So when he lifted the papers off the desk, he did not have a probable cause or a search warrant to lift those papers up. So his actions, he doesn't satisfy prong two, which means the document or the credit cards are not in plain view. So this would not amount to plain view. The officer might try to say, I mean, think about it in real life. Police officers, I have a lot of cops who are, I have a lot of friends who are cops, but I wouldn't put it past them to, snoop around while the suspect is in another room, snoop around, find the credit cards, and then just kind of toss the papers aside. And then in the report say, well, they were just sitting right there on the desk. And then it becomes, who's lying, right? That's another story. But think about it. In real life, the cop might just toss the papers aside and say, hey, in his report, say, hey, I found them. They were just sitting right there. So he would be basically saying, I had lawful permission to be there. I had the right to be there. She let me in. Doesn't matter that I deceived her and didn't tell her I was an undercover cop. That doesn't matter. The law, case law, which I believe is Lewis versus the United States, had determined that cops can use deceit to enter a premises, that you don't have protection from, basically in a nutshell, you don't have the right, like you can't tell somebody, like it's not reasonable to tell somebody incriminating evidence about yourself and believe that they're not going to tell somebody or that they're not going to tell the cops. You don't have that kind of protection. But the dude did not take action in this particular fact pattern. He did not have the authority to lift those papers up and go snooping around. So yeah, even though he had the right to be there in that room, if he had saw those credit cards just sitting on top of the papers as opposed to being underneath them, he'd be fine. He would have a plain view doctrine. And if you're on an essay and you're writing an essay on this type of fact pattern, you would absolutely want to jot down a title, plain view doctrine, and then analyze it this way. You would explain what plain view is, meaning that you have the right, the officer has the right to be where he is, and two, that he had a right to take the action that he took, meaning that he didn't lift the papers, but instead the credit cards were on top and he looked, they were in plain view, and then he seized them. So therefore we know that she did not assume the risk. She didn't assume the risk that he was going to go snooping around and lifting things up and find them. She only assumed the risk as so far as she allowed him into the room, and anything that he would have found actually in plain view would be fair game. But she did not assume the risk that he was going to go. In this situation, it doesn't fly that he went and did an illegal search. She's not assuming the risk that he's going to go digging and looking. It's just like if he was looking through closets, looking through bed, other rooms he wasn't allowed to be in, snooping around in drawers and stuff like that. So A, no, B, no, C, no. He didn't violate her rights when he deceived her that, he would, call Harvey. He'll vouch for me. No, he's good. A, no, it doesn't matter that it was immediately apparent because he had already before chronologically he lifted the papers before they became apparent that they were stolen, right? So he had already conducted a search. Therefore, once it was immediately apparent that they were stolen, that's fruit of the poisonous tree. Okay. And then B, no, the woman assumed the risk. She assumed the risk only insofar that anything that in plain view in that room would have been fair game. But because he didn't conduct an illegal search because he had no probable cause or a search warrant to lift those papers, he violated her Fourth Amendment rights. And what happened here is that it's an illegal search. And of course, when she's moving to suppress the evidence that was seized, he seized the cards. So the reason why those seized cards were obtained in violation of her Fourth Amendment's rights is because he did an unlawful search of her desk in that room. He lifted the papers when he had no PC and he had no search warrant. Therefore, the correct answer is going to be C. I hope that makes sense to you guys. This type of stuff happens it happens every single day. Every single day, cops have to navigate the Fourth Amendment when it comes to whether or not they have probable cause to, search a vehicle, search a house, whatever it is that they're conducting, whatever it is that they're doing, they have to work within the parameters of this. This rules that the police and the government have to abide by because our highest courts have said that we have a certain amount of privacy under the Fourth Amendment to be free from unlawful searches and seizures of property or life and things like that. So if you have any questions about this multiple choice question, drop a comment in the comment section, or if you disagree with something or you want to add something so that other people can take note of that, please drop your comment in the comment section. If you need not legal advice, but if you just need assistance with filling out forms or need some direction, you can call Legal Doc Guy or you can email us. I should get the number up here. I don't even have the phone number. That's kind of silly. Next time I'll put the phone number, but you could obviously email us at legaldocguy@yahoo.com and ask your question. Hey, what should I do in this situation? So for example, if you're getting divorced and you don't know what forms to fill out, give us a call. We'll be happy to tell you what forms to fill out. If you need help filling out those forms, we'll be happy to do that for you for a modest fee. Now our fees are way lower than you're going to pay for an attorney to do the same work, because I've worked, me and the people here, we've worked as law clerks. We got tons of years of experience. Myself, I got I got 10 years of experience doing this sort of stuff. I've worked for attorneys as law clerks, as a law clerk, and done tons of divorces or domestic violence restraining orders or small claim stuff, whatever you got, landlord tenant. I got me recently some tenants that were being wrongfully evicted. I got them $4,000 cash and almost 6 months rent free, and then we sued them for wrongful eviction, defamation, a bunch of other stuff. And I did all the work. Same thing a lawyer would do, but they represent themselves technically, right? I don't give them legal advice. I just tell them what their options are. They say, I want to do that. And then I draft it up. I have tons of years, almost 10 years of law and motion experience, drafted the complaint, filed it. I'm pretty sure we're going to get these guys like 20 G's for what these dumb landlords did. But anyway, give us a call at Legal Doc Guy. Next time I'll have the phone number here so you could easily jot it down. But it's 562-551-9997. Again, my name is Dre with Legal Doc Guy. This is the Legal Doc Guy podcast. We'll catch you guys on the next one.